Good afternoon, everybody. Welcome back to another Q&A of all things employment law related. My name is Chris Justice. I'm, of course, an employment lawyer with Samfiru Tumarkin. I work out of their Toronto offices, and as I say, today's all about answering as many questions as I can in the half hour. So if you've got questions regarding your employment, regarding something going on in the workplace, maybe you've been packaged out, maybe you just got let go and you've gotten a severance package and you're wondering whether or not it's fair. Whatever the questions are, do get them in today. And as I say, I'll do my best to answer as many as possible. And actually, speaking of severance packages and sort of what happens on the way out of the employment relationship, I wanted to kind of talk today about some things that I think a lot of people should at least be thinking about or considering when it comes to them having been let go and how to best move forward from there. There's still a lot of news coming out where mass layoffs are going on. A lot of cuts are being made, for example, in the tech industries. A lot of people are being let go. So yeah, exactly how is that going to affect somebody's severance entitlements? Does that mean that there may be more severance owed in the event of sort of an economic downturn or when a lot of jobs are being lost? Again, these are questions I'm going to just delve into off the top before I get into some of yours. So let's just consider a scenario. You've been let go. Your company has come to you and they've told you that they are letting you go without cause and they're offering you some kind of a severance offer. Now, one of the first things I think about is, was the manner of my termination, was that conducted in good faith? What are the reasons behind why I was let go? If there's something potentially discriminatory or something that's in extreme bad faith as far as the basis for my termination, then that can lead to damages, that can lead to compensation just for the fact that you were let go for a particular reason. Now, these cases are relatively rare, but if you are, for instance, let go on account of your race, your age, your sexual orientation, other factors and sort of things that are set out in the human rights legislation, if that's the basis, then of course that's going to be one clear instance of a bad faith manner of termination. There are other instances where maybe you were let go after having filed a formal complaint against the company. Maybe after having asked for an investigation to be done into something going on in the workplace. And so the timing of your termination might be suspicious, and you might think that you were let go perhaps in retaliation or in reprisal for bringing forward a valid complaint. And if that's the case, then you can also be entitled to additional damages on top of any severance. So that's why I say one of the first things to think about is, why am I being let go? What's the reasoning from the company? A lot of times people get told that they're being let go because they're just not the right fit, that they are going in different directions, that there's a reorganization going on. And a lot of people may not necessarily like being told these answers or may not think that they're the best answers in the world. But if there is some merit to those answers, then that from a legal perspective is a perfectly fine way to let somebody go, or a perfectly fine reason to let somebody go. But that's number one, is sort of, why was I let go? Now, assuming you are let go in good faith on a without cause basis, which the vast majority of people are, then the next question that comes to mind would be, is the severance package that I'm offered fair and reasonable? And then you start to think, well, they're giving me several weeks or several months. This seems pretty good to me, but in reality, most of the time you're offered a package on your way out, you're being given something that's way less than what you're probably going to be owed to as far as your full severance entitlements are concerned. So, the courts will look at things like, how old are you at the time you're let go? How long were you with the company at the time you were let go? What was your position? What kind of compensation or money were you making? And these are all going to be factored in primarily into sort of determining how much somebody should get. Now, a lot of people also misunderstand that just because they're there for a year or two or maybe 3, that they're not entitled to that much severance, when actually that's wrong. Somebody who's only been at a company for a few months, let alone a few years or longer, could still get 3, 4, 5, 6 months of severance. So if you have a relatively short period of time with a company and you're let go, just don't make the mistake of thinking that you're owed a lot less, or that you might be only owed a week or a month, because a lot of times, as I say, the entitlements are going to be much greater. But you want to get legal advice before you sign off on any package, full stop, because of the fact that most of these packages are very much below what you're probably entitled to normally. So as I say, don't sign any release. You could be signing away thousands, tens of thousands of dollars, if not more, thinking that the package you were given was fair, when you should have got a lawyer to look at it. You should have got some advice on whether or not it was acceptable, or whether you should have negotiated for a better amount. But definitely get legal advice before signing any full and final release or anything that the company is offering. Excuse me. Now that brings me to actually another point, which is when you are given a package, you are often told that they want the package signed and delivered back to them within about a week's time from the day you were let go. And a lot of people are, under pressure. They're a bit nervous. What happens if I don't get the documents signed in on time within the 7 days or within the deadline that the company's giving me? Does that mean that I'm going to forego, a large chunk of my severance package? And a lot of times in the package, they do say that if you don't sign it by a certain day, you will get, maybe a fraction of what they're offering you. But you don't want to fall into this trap of feeling that pressure too much to the point where you sign it, because the fact of the matter as well is that even though there is a deadline that's put on you to sign your paperwork, in the vast majority of cases, those deadlines just simply don't mean anything. They're simply there to put pressure on you to sign a deal that is going to be much more beneficial for the company than you. And so before thinking you're under pressure, you need to sign it, otherwise you're going to lose it. Again, get some legal advice. Even if you don't have time to get legal advice until after the deadline passes, if anything, ask the company for an extension, which most of them, if not all, do, and then get that legal advice. Anything before just signing the release in the first instance and taking whatever is being offered to you. So, that's another consideration, though, that I find a lot of people come into contact with, is just this issue of timing. And, do I have to get something in time, when the vast majority of people don't? So don't worry about that for the most part. There's another issue that I'll come across when people are let go, and when I'm trying to figure out what their severance entitlements are, or when they're trying to figure out what they are. And that has to do with the contract that they may have signed before they were let go. Whether they signed a contract at the time they're hired, or maybe they've signed a contract at some point later on in their employment. Sometimes when you're let go, the company that let you go is going to be referring back to this contract that you signed. And in that contract could be some language around what happens in the event of a termination. And usually that language is sort of focused on limiting your rights to just the bare minimum in the event of termination. But that is another consideration to take into account is, did I sign a contract? What does that contract say? And that's all the more reason why as well, if you're being told to sign a contract, whether it's at the beginning of a working relationship or afterwards, you want to get legal advice too. Because for all you're signing something that may tell you that you're getting, a certain amount of money every year and benefits and pension. But then there's going to be this fine print maybe on page 5 that talks about termination and what happens in the event that we terminate and how much money should we give you. And of course, the last thing on most people's minds is termination when they're signing a contract. But then that's when you find that it comes back to bite you later on, after you've been let go and after you've discovered you've signed something. So you want to make sure you have that handy as well for an employment lawyer to look at as far as what your contract says and whether it has any bearing on how much severance that you may be entitled to. But those are just some of the few main considerations or things to think about in the event of a termination. I'll get to more if I have time, but I'm just going to get into some questions now. I've got one question in from Sir on YouTube, who's asking or saying that they received severance in EI and they heard that EI kicks in after severance. And Sir is asking whether they can travel while they're on severance. So technically you can travel while you're getting severance, but if you are receiving EI, then there's at the very least an expectation from EI that while you're receiving those benefits, that you are given that you're giving reasonable efforts to look for work. Now, if you're on vacation for a week or two, probably won't matter. If it's more of an extended vacation that might significantly affect your ability to seek out employment, that could be an issue that you need an employment lawyer to maybe advise you on. But as far as just the fact of somebody getting both severance and EI, that is possible. Though usually EI, if someone's not already receiving EI is going to wait until after the severance has been paid in full. So for example, if you get, let's say, 6 months of a severance package, and you want to collect EI, in most cases, you're only going to be able to start collecting EI after the 6 months. You're not going to typically be able to collect both EI and severance overlapping with the same period. So depending on what the overlap is exactly, there may be an obligation to repay some money back to EI if you've already received it. But otherwise, you'll have typically EI sync up right after the severance payments end. I've got another question in from the Strong Mermaid on YouTube, who's saying that they understand using break time to get coffee or step away from their desk, but legally can an employer include washroom time in your scheduled breaks? So there are certain break times that are actually required under law, at least in Ontario, for example. There's going to be obviously usually a lunch break as well as a couple other breaks that have to be given in some form or fashion by the employer. So that's just in general, Stronger Mermaid. But as far as whether your employer can include washroom time in scheduled breaks, that's going to be a general no. It's going to come down to a case-by-case basis as far as, I guess, in a particular case, how much time is being spent in the washroom. I mean, there's always some context that can be potentially added into cases, but, your employer can't also, generally speaking, include washroom time into breaks, because for all I know, there could be some medical issue or health-related issue when it comes to washroom time. And if your employer is just blanket applying this rule across the board where all this washroom time gets added into your scheduled breaks, and then you no longer have the ability to take a break, then that can be a huge issue for employers. So they have to be careful about how they apply these rules, because first of all, if it's a very minor incident or issue, then that's generally not going to be acceptable. But even if it's something that's more major or taking up more of the time, they also need to be careful that they're considering other factors and whether accommodations need to be made or not. But without having a bit more information, Mermaid, I think it'd be better if you call in and we can kind of fully flesh out your situation to find out exactly what the problem is, how many breaks we're talking about, how long of a period this is going over, and also what the employer's policy says when it comes to staff using break time to go to the washroom. Because there can also be situations where the policy is not worded in the right way, or is actually potentially offside or illegal in some aspect. And you can look to attack the policy that way as well if you're trying to push back. But I'd say give us a call just so we can flesh out the problem in a bit more detail. I realize you're in Alberta. Now, we do have lawyers working out of that province as well. So definitely give us a shout and we can walk you through it all. Thanks, though, for the question. I've got another in from Liz on YouTube, who's saying that they've resigned, or they're asking, after resigning for constructive dismissal due to disability accommodation not being agreed to, do I report to my employer that I'm taking action against them now with a human rights claim? So, Liz, I would say, first of all, if you haven't done this already, get in touch with a lawyer, because if the employer has not accommodated your disability, then that absolutely can be a constructive dismissal. That can be tantamount to a termination, an employer's failure to accommodate. And not only can that potentially entitle you to severance, but also, of course, human rights compensation on top of that. Now, there are a few different avenues you can go down, though. You don't have to necessarily go down, let's say, for instance, the Ontario Human Rights Tribunal path. You could not go down the human rights path and instead decide to commence a civil action, a lawsuit in the Ontario Superior Court, for example. Now, the human rights path is not going to be able to allow you to collect legal fees that you may have incurred in going down that path, whereas the civil litigation, the lawsuit path, could actually help compensate you for legal fees that you've incurred, while at the same time getting most, if not all, of what you could get under the human rights path. Now, the human rights path may be potentially quicker in getting to an end date. So there are pros and cons to each path you take, but it also might be possible that you can negotiate a package with your employer without having to pursue human rights or civil litigation. Even though accommodation cases can sometimes be tricky, it still may be possible to negotiate without having to commence a lawsuit or anything of that sort whatsoever, which I'm sure in most cases is going to be preferred. So you may very well have a very legitimate case, but I would usually try and give the employer one chance to rectify things maybe early on, and then failing that, if it's worth it and everything is on side with you there, then definitely going down the human rights path or the civil litigation path would probably be a recommended choice. But you may just want to hold tight for the time being before telling them that, and get some legal advice. And then also the lawyer can kind of help you communicate with your employer if that's to be the case, as far as going about next steps. But thanks for your question. That definitely does seem like a serious one, the failure to accommodate someone's disability. I've got another question in from Ash on YouTube, who's asking, what happens if you don't have a signed employment contract? Are you still able to receive severance without one? And actually, it's probably going to be in your better interest if you don't have a contract, because yes, you don't need a contract to get severance. If you, for instance, work in Ontario or Alberta or British Columbia, you're an employee there, you're non-unionized, and you've been let go without cause, and you never signed anything your whole time there, then yes, you're still generally entitled to severance, and you're probably entitled to more severance than had you signed the contract. In most cases, a contract, or you being asked to sign a contract, is not going to be in your favor. It's going to be mostly, if not entirely, in the employer's favor. So a lot of these jobs that start with a handshake or just a verbal, contract, so to speak, are in a lot of cases a lot better than a contract. The contract, if anything, adds another hurdling block or stumbling block to get over, to try and get as much severance as possible. But without a contract in place, your severance entitlements aren't going to be restricted, and you're going to at least have potential to get your full severance. So that would be good. And that's, again, reason why people need to be careful before they sign contracts, because you never know what's in them. And as I say, in most cases, it's much more beneficial just there not to be one. It just so happens, though, that most employers also typically require one. So that's where the catch-22 lies there. But thanks for your question. I've got another one in from Rudy on YouTube, who's saying that they work part-time for a company. And the minimum for this job is supposed to be 18 hours a week. If I'm getting less than that, is that illegal? So if you work part-time for a company and there is a contract or an agreement or an expectation in place where you work 18 hours a week, and your employer starts booking you less than 18 hours a week, which was the deal, the arrangement, then that would be a breach of your specific contract and could entitle you to either your full severance or also additional damages for either the breach of the contract itself, or possibly a breach of the employment standards legislation. So really this applies to anyone, but if you're an employee who is supposed to work a set number of hours a week or earn a certain amount of money per week, and regardless of whether it's illegal or not, your employer comes to you and says, we're changing things up on you, that is obviously going to be a red flag. And even if it's not a violation of employment standards per se, it could still be offside with the law in another aspect and could entitle you to your full severance. So like I say, any changes to hours, location, your pay, your job itself, it's going to start raising red flags, and you should be on alert and sort of be aware at least that you have potential options where you can kind of dig in and say, no, I don't agree with that. And like I say, potentially go after severance. But before you do any of that, whether it's Rudy or anyone else that's in a position where the company is sort of going against their word or what they're required to give to you, give us a call, get some legal advice. And again, we can help kind of talk you through that, make sure that you're saying all the right things, so that if there does come a time for you to leave the company or ties are severed in some way, that you're going to be in the best position to get, as much compensation as you can and just access to your full rights at that point. I've got a follow-up question actually from Liz, who had earlier stated that they were constructively dismissed for failure to accommodate disability. Apparently Liz has spent a number of months trying to come to terms, and legal advice is to make an issue and be heard. So yeah, Liz, if let's say lawyers on your behalf have tried negotiating terms to settle the case or come to some sort of resolution, and they just simply don't want to do anything, and there's a strong, valid, constructive dismissal case on your end, then, usually my recommendation would be to pursue that further. because what's the alternative? That you just stay off work and do nothing and just hope that they do the right thing? Well, yeah, normally that's not going to happen. So unfortunately, you may have to take that necessary evil, like you say, be heard, whether it's going down the human rights path specifically or the more general litigation path. Either way, that could very well be the next move to make. So yeah, I would say get some legal advice on sort of what direction is more beneficial or advantageous to you to pursue. But yeah, if you've already tried and they don't want to do it, then that may be there may be no other option left. I've got another question in from YYZ on YouTube who's saying, if a company lays off due to business migrating outside of Canada and offers a promotion, can we still decline and be eligible for severance? So, and the promotion is no new contract, some of the same duties. So if you, first of all, if you've been laid off, whether you mean permanently laid off, which is called a termination, or you mean laid off on a temporary basis. So say your company comes to you and says, we are taking a hit on the business side. We have to lay you off for a certain period of time. We don't know how long, but if you want to take on this different job, which according to YYZ has some of the same duties, the company may be trying to offer that to you as, I guess, an alternative to a temporary layoff. I wouldn't say that you have any obligation to accept another job if the job itself is significantly different than what you were doing at the time, right? So if I'm a lawyer and I'm being told I'm being laid off, but there's a very similar lawyer job available at the same firm, that might be one thing. But if the company turns around and offers me a job as secretary when I was a lawyer for so many years, well, then I can decline that offer and that's not going to be held against me. And if my employment otherwise comes to an end at that point, then yes, I'm still going to be eligible for severance. Or even if I'm just temporarily laid off and they don't have any other job for me, I could still get severance eligibility there too. So it may, YYZ, it may come down to what duties are the same, how similar, I guess, this apparent promotion is. But if, as a matter of fact, you've been terminated as opposed to a temporary layoff, then you're probably at least looking at some severance. And it would just be a question of how much exactly, which I think you should give us a call and we can talk further about. I just wasn't clear if it was a temporary or permanent layoff rather. But yeah, give us a call and I'm sure there's something that can be done. It looks like you're probably going to be eligible for severance based on your comment and you want to make sure you get the most possible. I've got another question in from Steve on YouTube who's saying or asking, if you have to take an unpaid leave for medical reasons, is your job protected or can your employer let you go for being off longer than their policy allows? So generally speaking, yes, if you take a unpaid leave off for medical reasons and you have the backing and support of your family doctor, physician, whomever, and it verifies that you cannot at that time perform your job or the vast majority of your job, then you can take a medical leave 100%, and your employer does have to keep your job protected to a certain point. So employers have to accommodate somebody's medical issues, what they call up to undue hardship. So it just kind of depends on the size of the company. In some respect, it depends on what the accommodation being asked for is. So for example, if I had a condition that I needed accommodation for, but it required my employer to invest, $1 million into the business, and let's just say they're a small mom and pop shop, then that's going to be different than if I work for Amazon or Walmart and I'm asking for, an ergonomic chair or whatever. So just because there's inconvenience or burden to a company in order to accommodate somebody, that doesn't mean that a company can just decline to give that accommodation. So that's just a more general point, that you need to be accommodated to a very high degree up to the point of undue hardship. And I've given a couple examples in terms of, when someone's ready to return, if there's an extra cost for them to return to be accommodated, something normally employers have to comply with. But if the accommodation is just simply allowing you to remain off work, then that's another form of accommodation that employers have to do, again, up to the point of undue hardship, or up to the point of what they call frustration of contract. So, for example, there could be a situation where you suffer an injury that renders you completely incapable of doing your job for 2 years, but then after 2 years, or maybe even after 3 years, you're able to come back. Now, that may be a long time, and a lot of employers may not want to keep you on the books, so to speak, for 2, 3 years. But if there's evidence to suggest that, maybe it's been that long, but there's improvement and that maybe it's expected that you're going to be coming back soon, even if it's been 2 or 3 years, in a lot of cases, employers have to keep your job open. Now, on the other hand, if you think of a scenario where you've been injured and you've been completely unable to do your job for, let's say, 5, 6 years, and your doctor is still saying that as of the 5 or 6 or 7 year mark, that there's really no hope for you to ever go back to this job and that the prognosis is very poor, then that may be a point in time where the employer doesn't have to keep your job open anymore and can actually go through this process of what's known as frustration of contract, where the employer will come to you and say something along the lines of, it's been so many years since you've been off. We've got updates from your doctor, but it still seems after 5, 6, 7 years that there's no hope of you returning. There's no foreseeable return to work date. And so unfortunately, your contract with our company has been frustrated. We're going to have to sever ties with you, at which point you'll then receive your bare minimum severance. It may not be your full severance or what you'd ideally like to hope for, but you'll still get some form of severance in that sense. So, Steve, I guess it just depends on how long we're talking, as far as how long you're off work and what the prognosis from the doctor would be as of that time. Like I say, if there's improvement and you're maybe expected to come back in the not so distant future, that's one thing. But if there's been several years past and nothing's really changed, then the employer doesn't have to generally hold open your position for 10, 20, 30 years. Again, there's going to be a point at which they can say, enough's enough. But a lot of times, if not most of the time, employers don't usually wait for that point. They'll often try to pull the trigger a bit sooner, which can kind of get them in hot water. So, Steve, or anyone for that matter, if you're in a situation where you're not being accommodated to the degree that you think you should be, or your employer's trying to just cut ties with you because you've been away for too long, definitely give us a shout, because, as I say, there could be, human rights damages owed there. There could be full severance damages owed there. I've got one more question from Kevin on Facebook, who's saying that they were forced, I think, to retire after 26 years. They hired a lawyer to file a lawsuit with the Ontario Labour Relations Board, and they were told that they were past the time allowed. So the Relations Board dismissed the case, but they were told that they could actually get reconsideration due to mental health issues, PTSD, and taking care of his wife or their wife who was disabled. Lawyer won't do anything more until they pay more. Am I wasting my time, as the board will just decline my claim? So yes, there are limitation periods. There are limitation periods on a variety of things when it comes to the law. Like, for example, if you are looking to commence a lawsuit, or you want to bring a lawsuit against a company from a non-unionized sector, you generally have 2 years to do so. So if you're let go today and you don't sue the company by February the 12th of 2016, then you're not going to be able to sue them generally, though there are some exceptions. Kevin's pointed out, some considerations like mental health issues, maybe having some other things going on in one's life that explain why perhaps they waited longer. And I think on that basis, there definitely can be some consideration given to allowing a claim to go through. Like, example, in the non-unionized context, I know there are some cases where you go past the 2-year mark, and there are some factors that come into consideration that allow that claim or those papers to be filed, despite the fact that they were typically late. So I'm not going to say that's a complete non-issue, but I guess it comes down to the likelihood that the reconsideration will succeed. And if there's a strong likelihood that it won't, and your employment or the lawyer that you're working for won't do anything more until they're paid, I think it's just going to be a matter of whether you want to spend more money in legal fees to take a chance of having this reconsidered. And then it will come down, hopefully, to maybe your employment lawyer advising what the chances they think are on the reconsideration. That might help sort of gauge whether it's worth the risk or reward. But that's probably as much as I can say at this point without having more information. So happy to give a second opinion if you'd like, if you want to call in. But otherwise, I'd just find out if I can from the lawyer what the odds of the reconsideration going forward or being successful are, if you don't already have that info. Maybe that was something you talked about before. and then try to weigh it up. But if you need some further thoughts or you want to bounce some ideas off somebody, then like I say, feel free to give us a shout. That's my time though for today. So I thank everyone for their questions. As always, I'll be back to answer more, but we do have sessions going on continuously. You see down below there actually on the 14th. If you have a question regarding your employment situation, maybe you asked it today, I didn't get around to it, or you've got something by Wednesday, tune in February 14th. You see there 1 o'clock Eastern with Mr. Samfiru himself. But as far as I'm concerned, I'll be signing off today. Thanks again, everyone. It was a pleasure. Do take care and enjoy the rest of your Monday. Bye for now.